I want to thank you all very much for bringing me here on this beautiful snowy day. And it was a pleasure. Also, thank you to your dean. It was a pleasure talking to you at lunch. And thank you, Professor Botterill. I like to take credit for my students' success. So even though Professor Botterill was a highly successful scholar before he ever met me, I'm still going to take credit for all that he's accomplished since then. So thank you very much for the invitation. And I also would very much like to thank Stephen Coxford for his generosity in endowing this lecture today. So, Black reparations. The topic, the question, the legal and political possibility have long been relegated to fringe radical racial movements within the United States. I documented in a 2010 article how Black calls for reparations were a parallel social and political movement to the more conventionally known and widely endorsed civil rights movement. And in fact, if the claims and the calls of former slaves for pensions can be understood as reparations, then the reparations movement preceded the formal civil rights movement by several decades. Yet, despite several lawsuits and some very important legal scholarship in the 1990s and 2000s, the reparations movement has been unable to gain significant political or cultural traction. Two things have revitalized interest in Black reparations. U.S. public intellectual Ta-Nehisi Coates' provocative article last year in The Atlantic magazine called The Case for Reparations, and also events in Ferguson, Missouri, 10 miles from where I live and work. The latter has shocked the international community and laid bare a set of economic deprivations, police misconduct, both systemic and ad hoc, and judicial policies designed to penalize poverty, all in the service of, or at least with the effect, of enacting ongoing racism. And I'll say with a sense of collective embarrassment that most of us did not even realize what was happening a mere 10 miles away from us. Both of these, Ta-Nehisi Coates' article and subsequent lecture tour, as well as events in Ferguson, have led to African American reparations emerging again as a matter of serious academic inquiry, with scholars debating what, if any, doctrinal platform could support a juridical claim made through the courts. Several legal scholars, including Western Ontario's own Dennis Klemchuk, have generated models of reparations based on torts and unjust enrichment for the wrongfully expropriated labor of generations of enslaved Black workers. And as this picture makes clear, this continued, perhaps it doesn't make clear, but I should make clear, these men are not enslaved. These are men working on a chain gang. So the expropriation of Black labor continued well beyond formal American slavery. These private law models are grounded in corrective justice claims, raising the question of whether corrective justice, or any extant form of justice, is adequate to the juridical task of supporting reparations for slavery and racism in the U.S. Today, I'd like to consider which, if any, model of justice could sustain such a claim. Now, in a broader version of this paper, I rehearse in perhaps painstaking detail what I view as the distinguishing features of U.S. slavery. And I do so both to introduce those unfamiliar with the system and the legal regime, and I also do so to engage with those who make what Viviana Zelizer would call no different arguments, that slavery was no different from class-based or other historic systems of repression. Some iterations of feminism make this, but not as seriously or systemically, I think, as the class-based arguments are made. And these arguments come primarily from what we would call the left. The left, right? I also do so to engage arguments that slavery's wrongs were limited to a few wrongdoers, or that it is too long gone an injury, what I call the let bygones be bygones argument, and that typically comes from the political right in the United States. So let me say quickly 4 distinguishing features, which I'd be happy to elaborate and question and answer, but 4 features that I think distinguish slavery in the United States from other forms of social repression, including class-based subordination and also gender-based subordination. The first is that slavery was state mandated. And this is an important one. This was not, quote, merely private individuals subordinating each other. They did so not only with the authorization of the state, but indeed by the mandate of the state. And this leads to a second distinguishing feature, which was the structural nature of slavery's subordination. Slavery sharply restricted any efforts by upper caste members, that would be slaveholders, to disrupt the slaveholding order. Restrictions included things like increasingly strict limits on the ability of slaveholders to manumit their slaves, which clearly would have undermined the system. It included property-based restrictions on the kinds of things that masters could allow their slaves to do. For instance, if a master wanted to allow a slave to hire himself out, or if a master wanted to allow a slave to own a gun, perhaps to hunt, to supplement the slave's family's food, the state would restrict that. And finally, very significant restrictions on the free speech of all of the white people and all of the free people in the slaveholding community, all with the goal, again, of limiting the ability of any single free white individual, including upper class individuals, to disrupt the system. There were also, as I've written about extensively, restrictions on intimacy and family formation as a point of potential transfer or mobility or changing caste, right? So if you can imagine slaveholders as being the equivalent of Bill Gates today, some of the wealthiest people in the United States, many of whom were creating what I called shadow families, families with the black women with whom they were sleeping, and some of whom, very small numbers of whom, then wanted to free their shadow families and transfer vast sums of wealth to them. This would also completely undermine what the state wanted to be a race-based system of slavery, and laws significantly and severely restricted this. So we have state mandated, we have the structural nature. In addition, borrowing from philosopher Amartya Sen, I will also say that slavery radically suppressed black capabilities as a way of maintaining social caste. And this becomes very important in understanding how slavery, how race-based slavery differed from class-based oppressions, which were certainly happening at the same time to free white workers and particularly to immigrant workers from Europe. But in contrast, with class-based restrictions, slaves found themselves structurally disabled from gaining the core capabilities that were intrinsic to being a full citizen in America's burgeoning capitalist democracy. And these include things like literacy, the ability to have an intact family, the ability to transmit wealth among a family. All of these were things that were criminalized under slavery that were not denied to poor white workers. So limits on capabilities, I think, becomes another very important way of understanding, again, the structural state-mandated injuries of slavery. And finally, a fourth distinguishing feature I borrow from sociologist Orlando Patterson. And Patterson has this vision of slavery as social death. Patterson's argument is that what distinguishes the slave from the free person is that the slave is socially dead, meaning the slave cannot make any claims on the state or society, nor can the society or the state make any claims on the slave. Importantly, Patterson points out that part of the measure of slavery is not just the state of slavery itself, but what happens when that state is removed. In other words, when the slave is manumitted or the slave is freed, or what he calls social rebirth. Now, in a society where the restriction is purely about the slave status, then once a slave is freed and is quote-unquote reborn, there would be no ongoing distinctions between the freed slave and other free people in the society. And indeed, there are some enslaving societies where once a slave becomes free, they go on to become a full functioning member of the society, a full citizen. Some even go on to achieve a royal status or leadership status in the society. In the United States, in contrast, social rebirth was sharply restricted. And in fact, during the slavery era itself, the southern states went on a march to sharply restrict any distinction between free blacks and enslaved blacks. So this idea of social rebirth was quite squelched, which again tells us something about slavery itself. So it is these four features that I argue distinguish slavery, both from slavery in the US, both from other forms of slavery around the world historically, and from other types of systemic repression, again, most notably class-based and gender-based repression. So increasingly, as I said, legal scholars are debating whether to conceptualize and defend reparations as a matter of corrective or of distributive justice. And historically, at least through the 20th century, these were the two dominant models of justice in the Anglo-American system. Distributive justice emphasizes the appropriate distribution or redistribution of resources in society based on precepts of fairness, need, citizenship or other status, democracy. In contrast, corrective justice has a much more limited jurisdiction, and I quote here, "It does not invite judgments about the fair distribution of wealth in society, but about what is right between two particular people, considering equity and conscience, or by the ties of natural justice." The primary task of corrective justice, then, is to determine who held an initial entitlement or right, and then whether another private actor breached or violated that entitlement or right, and to then assess a remedy, overwhelmingly monetary relief. Unlike distributive justice, corrective justice concerns itself with the restoration of prior positions without consideration, I would contend, of the justness of those initial positions, those prior positions. In short, corrective justice turns to the market as opposed to the criminal system or the political process to rectify injuries and vindicate entitlements. And a brief example should suffice. Imagine that I kick you and I injure you. Dean, I kick you, I injure you. I bet it does. Fantasies around the room, I'm sure. I'm an administrator, I can joke about that. In classic corrective justice, if I kick and injure your dean, I would have to compensate him to restore him economically to his position before I violated his entitlement and his bodily integrity. Alternatively, and I'll also say importantly, that if I kick you and injure you, my recompense, my compensation of you, does not turn on any moral judgments about your character. Right? I cannot say as a defense, well, he'll just squander it or use it for things that I don't personally agree with. He's a known drug dealer, or he doesn't make his child support payments. I know nothing about you, I'm just making all this up. But there's nothing about his moral standing as a member of our community that I can use to defend myself under a corrective justice model. Really the focus is on his entitlement to be restored to his prior position of full bodily integrity. Now, alternatively, instead of a corrective justice model, society might provide support for the dean's injury. And this would not be based on righting a wrong. The state would not care whether his disability was inflicted by a third party, his own carelessness, or an accident of birth. Rather, it would be part of what the state owed all people who shared his disability, and that would be a distributive justice model. So most who advocate reparations as corrective justice do so through a torts-based analysis or a private law analysis, often unjust enrichment. And I understand that I'm here among the philosophers, so we can really tease out more what exactly unjust enrichment is here and how it relates more broadly to corrective justice. But for these purposes, I would say that most who advocate reparations as corrective justice do so through torts-based lens or unjust enrichment-based lens, which is an equitable principle that wrongfully gotten gains must be disgorged. And while in civil law, unjust enrichment enjoys its own conceptual and doctrinal apparatus as restitution, in common law countries, I would argue it's more generally viewed as a subspecies of torts. Again, we can debate that. But these private law models are grounded in corrective justice claims, and in some instances, such as Hanak Dagan, are self-conscious efforts to rehabilitate private law doctrine more generally. Now, I'm a big fan of all of this work, and I think it was some of the best work that had been done legally on reparations in generations, since Boris Bittker wrote a book about it in the 1970s, Bittker being a big tax professor. But I would still argue that these private law claims grounded in corrective justice misconceive the fundamental injuries of slavery. And I would argue that remedying these effects, enforced social death, an ongoing repression of capabilities, denial of social rebirth, are probably beyond the scope of unjust enrichment and restitutionary measures, whether conceived conventionally or, as some unjust enrichment scholars would do, more radically. Nor, I would argue, nor can they capture all of the defendant's benefit, whether measured as labor, profits, or intangible racial wages. I'm happy to talk about that more in Q&A. Reparations grounded in corrective justice, I worry, also misconceives causation. As I discussed above, corrective justice is predicated on rectifying breaches of duty, typically by private actors. And following this logic, unjust enrichment reparations claims conceived against corporations or family businesses still emphasize the defendant's misconduct. But I would argue that slavery's enforced systems involved multiple institutions, including political and legal ones. It was law that criminalized slave literacy. It was law that criminalized freedom of assembly and self-defense by slaves. It was law that deprived blacks of meaningful economic personality and custodial power over their kinfolk. It was law that denied enslaved persons due process in both the civil and the criminal arenas. And it was law that refused to protect African Americans from violence. It was political institutions that excluded enslaved persons from citizenship and democratic processes. And it was both law and politics that treated free blacks more akin to slaves than to free whites. And this set of brutalizations and degradations were inflicted not just by private acts, but were intimately connected to the political, economic, and the sexual ordering, first of slavery and then of Jim Crow. In fact, those private actors who did attempt to defy slavery's what I call caste regime could suffer legal or social reprobation themselves. Or at a minimum, they found their efforts at amelioration blocked by law. And the point here is not to make a moral judgment in defense of slaveholders or others who are complicit in these regimes. Contemporary human rights discourse has demonstrated the poverty of these efforts. Rather, my point is to suggest that corrective justice, grounded in repairing discrete breaches of the private law ordering, may not be up to the task of segregating individual wrongdoers from structurally mandated social death, structurally mandated repression of core capabilities, and structurally mandated sexual servitude. I also have an important legitimization concern about corrective justice. As I argued above, unjust enrichment can be seen as classic corrective justice in that it seeks to return the plaintiff to her rightful position, which has been disrupted by inattention to or purposeful breach of duty. And this formulation of liability as flowing from individual actors, or flowing between individual actors, assumes the legitimacy of the underlying regime and its allocation of entitlements. Corrective justice, by and large, does not question the private law's prior distribution of rights and duties, powers and immunities, abilities and disabilities. Rather, causation and liability are predicated on discrete violations of those entitlements as determined by the private law regime. In the context of black reparations, these private law proposals have configured the wrongful act as individual slaveholders' expropriation of uncompensated labor. But this is an odd formulation of causation. It ignores all of the structural forces enslaving millions, in essence, hundreds of years of kidnapping and captivity of the slave society to focus only on the failure of individual slaveholders to pay wages to the labor force. Or in Hanak Dagan's more radical formulation, it goes beyond a wage or income formulation, but still limits its focus to the wrongful accumulation of wealth more generally. In addition, all of the other entitlements slaveholders claimed, most prominently to extract sexual and reproductive labor from the workforce, go unchallenged. Reparative models grounded in corrective justice then reinforce, I worry, the legitimacy of the underlying legal regime. And it is this legitimacy that reparations is seeking to challenge. what the ideal of reparative relief and discourse allows us is the possibility of troubling the legitimacy of these initial allocations. Hence, reparative discourse and the corrective justice rubric may be incompatible at best. So in the end, corrective justice may not be able to conduct the sort of historical audit that we need to grapple with slavery's legacy, its unresurrected social death, its ongoing repression of capabilities, and what I've called elsewhere, its sexual political economy. Now, importantly, I believe that corrective justice is a better fit for reparations than the other dominant form of justice, distributive justice. But that is a topic for another paper, literally. So, if corrective justice and also distributive justice are both ultimately not up to the task of offering philosophical support for Black reparations, where does that leave us? And I'd like to contend that perhaps the best juridical underpinning for reparations is transitional justice. So we can talk about whether transitional justice would be seen as public law or not, but I believe it is. Now, relative to its predecessors, corrective justice and distributive justice, relative to its predecessors, transitional justice is a new conception of justice that has grown into its own over the last 2 decades. Scholars such as Ruti Teitel developed it to capture the wave of collapsing totalitarian states in the late 1980s and 1990s, and the particular pressures that their uneasy efforts to democratize placed on the rule of law, generating heated debates about whether there is an obligation to punish in democratic transitions. From the collapse of communism in Eastern and Central Europe, to the end of military dictatorships in Latin American states, to the fall of apartheid in South Africa, political leaders, scholars, and activists fought over punishment or impunity. Which would best further the goals of democratization and liberalization? Teitel and others contended that the particular pressures of finding liberal responses to illiberal, often totalitarian states could not be sufficiently parsed or resolved under extant notions of justice and required a template more specific to the political context of democratic transition. Rejecting the usual universals and absolutes that characterize corrective justice and distributive justice, transitional justice advocates urged, quote, various legal responses should be evaluated on the basis of their prospects for democracy, close quote. The evils of the ancien regime would be judged and punished according to relevant political and institutional constraints. Transitional justice then is, quote, a new jurisprudence rooted in prior political injustice, close quote, characterized by the need to negotiate the fragility and the instability of democratic transition. Because the transition from illiberal state to liberal democracy is almost a conundrum, it warranted a new jurisprudence. So following Teitel's template, and the literature has grown far more massive since her initial book, but for the sake of simplicity, I'm sort of focusing on her initial setting things out. So following Teitel's template, 3 things distinguish transitional justice. First, the desire by a subsequent political regime to both distance itself from and judge a prior regime now judged to be illiberal. In other words, it follows a shift in political orders and, quote, arises within a bounded period spanning 2 regimes, close quote. Now, importantly, this shift is a rupture in the political order, often revolutionary in nature, not the ordinary and regular product of democracy as in the transition from Democrat to Republican offices or administrations. Second, the new order aspires to remake the state's basic political, social, and economic institutions in order to transition to liberalism and democracy. Third, the new order manifests a willingness to make atonement to victims of the previous regime, now judged to have been unfairly or criminally treated. And these 3 things, distancing from and explicitly judging the previous regime, the aspiration to remake the society's core institutions to do so, to distance, And third, atonement to victims of the previous regime are what distinguish and characterize transitional justice from other forms of justice. In addition, compared to both corrective and distributive justice, transitional justice can appear oddly paradoxical. Corrective justice typically is characterized as being backward-looking. It focuses attention on an initial set of entitlements and what the behavior is that disrupted them. Distributive justice can be characterized typically as present-focused, what would create a fair outcome in the present. Transitional justice takes a forward-looking approach, but does so by being backward-looking. It focuses attention on the injustices of the prior regime, seeking to address them with the explicit purpose of creating a just political future. Transitional justice then encompasses aspects of both forward and backward-looking justice, but toward a particular goal, which is transitioning from an illiberal to a liberal state. Now, transitional justice may entail both distributive and corrective measures. It can involve multiple branches of government, and it can be either externally or internally imposed. Externally imposed or internally adopted, I suppose. It can take several forms, but there are three primary ones. Criminal trials prosecute those now judged by the current regime to have been wrongdoers. Indeed, Titel has contended this is historically the most popular form of transitioning, and it is the one that resonates the most in the public imagination about transitions. Alternatively, in the modern era, some transitioning nations have turned to truth and reconciliation commissions in lieu of trials. South Africa is the most visible and arguably the most successful example of this. People debate its success in South Africa. And the final form of transitional justice is reparations, which are designed to compensate victims of the prior illiberal order. Other scholars, most notably Melissa Nobles, urge also powerful symbolic measures as part of transitional justice, most notably apologies. So, for instance, Nobles observes that for many years, every year, a Turkish ambassador to Armenia was killed because the Turkish people refused to apologize for genocide against the Armenians. Now, part of Titel's point is that all of these forms need not be part of every transitional justice regime, nor should they be. Rather, true to the underlying goals of transitional justice, the appropriateness of the form is contingent on the prior injustice. For instance, criminal trials are most appropriate when we are trying to address prior wrongdoing that was either done with impunity or that even violated the previous criminal order. Truth and Reconciliation Commission, she contends, are most appropriate when much of the wrong and damage to the prior state was done through secrecy and denial, frequently as a mechanism of terrorizing populations. So think about disappearing people, for instance. Reparations, she says, perhaps the most common transitional form, reparatory justice's pervasiveness reflects its multiple roles and complex functions in periods of radical political change. Reparatory measures appear most definitional of the liberalizing move, as these responses instantiate recognition of individual rights. The equal protection of individual rights is fundamental to the liberal state, and therefore this remedy plays an important constructive role in periods seeking to reestablish the rule of law." Close quote. Hence, in its classic formulation, transitional justice is enacted by sovereign states. And unlike human rights discourse, the primary goal of transitional justice is to effect a shift in a state from illiberal to democratic. Protecting individual or even collective rights is a necessary part of that, but it is not the primary metric. And transitional justice may incorporate both distributive and corrective measures, but it is conceptually distinct from both. Unlike distributive or corrective justice, while transitional justice may seek to compensate injuries, it is because of the association of those injuries with the wrongs of a state and its social order, not based on purely individual wrongs or abstract needs. Indeed, in its desire to remake institutions, transitional justice transcends the typical property/liability rules of private law, often including them to have been unjust. Transitional justice is fundamentally about the political identity of states and their members. Other entities and individuals may be drafted to implement transitional justice, including its reparative justice, but final responsibility lies with the state. And I'll give you a quick example here, the Korean comfort women. Has anyone been following debates over the Korean comfort women? Any human rights types in the audience? A couple of you. In Korea, during the war, the Japanese government authorized its military to effectively kidnap and enslave many women and girls in Korea to, as the Japanese government contended for a long time, these women were prostitutes. The women contended that they were sexually enslaved, and they had no choice. And because because of Korean culture, many of these women, when they were returned to their hometowns, found themselves outcast and castigated within their own communities. In about the 80s and 90s, the comfort women began to demand apologies and reparations. And for a long time, the Japanese government just kept them at arm's length. Finally, in the late 2000s, some very wealthy private corporations in Japan began to offer to pay reparations to the women. It was getting massive human rights international attention. So it was sort of, here's some money. But the women rejected it. They said, we will not accept any money as reparations unless it comes with an apology and admission of guilt from the government. So they held fast on that. And that just helps us understand the difference between, again, corrective justice, right, or private law remedies versus what they saw. And you could, in their minds, it would have been part of Japan's transition from its pre-war and wartime status to being fully a member of the Western order of democracies today. So it's really quite a fascinating ongoing debate. And finally, transitional justice differs from other related models of justice in several important ways. I'll just point out one. U.S. legal scholar Roy Brooks has posited an atonement model for black reparations. Brooks' conception of atonement shares much, I think, with transitional justice. Like transitional justice, atonement is a victim-centered model of justice, and it stresses the need for states to be moral agents and actors. But there's a crucial difference between transitional justice and Brooks' model of atonement. One of Brooks' key features is forgiveness, that victims must forgive the perpetrators. In contrast, as Margaret Urban Walker notes, transitional justice requires something very different from victims: hope and trust. And this is a subtle yet crucial difference, I would contend. While Brooks' model imposes a present requirement on victims to immediately forgive, the present requirement of transitional justice is to believe in the future and to allow the state to gain one's trust through its actions. I'd like to pursue with my remaining time what is a relatively brief point in Titel's book to make a case for the United States as an instance of unfinished transitional justice and why that could offer juridical support for the third form of transitional justice, reparations. I have about 5 minutes left. Is that about right? Okay. The point of this section is neither to defend nor dispute transitional justice, but rather to consider whether it could provide the best juridical support for black reparations. So first, Titel characterizes transitional justice as characterizing sovereign states that transition from illiberal to liberal. Now, to many, characterizing the United States as illiberal might seem odd. Well, not in Canada, you guys. But in many parts of the world, and certainly in the U.S., to characterize us as illiberal might seem odd and sort of outrageous. The U.S. was the modern world's first democracy. and one that was explicitly founded on liberal Enlightenment norms. And while our founding fathers vigorously disagreed about how to construct the ideal democracy, they agreed on the need to apply Enlightenment principles to found a government that would live up to the liberal ideals of the Enlightenment. And these included respect for the individual, rights-based government, restrictions on the power of government, and the free circulation of ideas and thoughts, among others. Now, while the first modern democracy, the U.S. still harbored deeply illiberal structures and sentiments. These included class-based deprivations and, of course, the exclusion of women from full citizenship for well over 2 centuries. Even following the right to vote, women in the U.S. did not achieve formal equality until the sex equality cases in the 1970s. However, the nation's illiberalism was most painfully apparent in slavery, an intrinsically anti-liberal institution. The New World slavery embraced by the U.S. contradicted liberalism in multiple ways. Most obviously, slavery contradicts liberalism in its casting people as the legal property of others. Not only does it dehumanize the enslaved, but it easily converts masters into political and social despots. In addition, slavery's illiberalism spilled over black bodies onto those of white women and poor whites as well. The particular form slavery took in the U.S. led the plantocracy to rapidly oppose wage markets with devastating effects on working-class whites that would last well into the 20th century. And in addition, as I have argued elsewhere, slavery comprised gender supremacy in addition to racial supremacy. Slavery also foreclosed the free circulation of ideas and debate, core principles of Enlightenment liberalism, which Drew Faust, now president of Harvard, outlines in just beautiful detail in her book, Sacred Circle. The enslaving states had law, common law, statutes, constitutions, and regulations, as did the nominally free states, of course. Yet Southern judges struggled mightily to reconcile legal norms grounded in individual rights and capabilities with the demands of characterizing people as property and the raw and brute application of power. From criminal cases involving homicide to private law of contract, inheritance, and mortgages, to family law, to employment law, to peculiarly slave laws such as manumission rules, Southern judges struggled every day to maintain slavery's structural subordination and disenfranchisement while adhering to a nominal rule of law. Judges deployed all manner of strategies to reconcile slavery with the rule of law, from outright defiance to Judge Thomas Ruffin's strategic sentimentality. None, however, could fully master the task of reconciling this anti-liberal institution with the demands of a burgeoning liberal democracy. Nor could this illiberal regime be confined to the southern states themselves. As multiple historians and scholars have demonstrated, the entire sovereign United States was a slave society, which led so many of my forebears, of course, to escape to your country, Canada. If its commitment to slavery maintained the U.S. as a fundamentally illiberal nation, then can the end of slavery and the post-war amendments be understood as a transition to a liberal regime? The 13th Amendment expanded the Emancipation Proclamation to constitutionally bar slavery in all of the states. The 15th Amendment formally enfranchised black men. And in its guarantees of both equal protection and due process, the 14th Amendment installed equality and access to government as central U.S. constitutional principles. And manifold constitutional scholars have evaluated the effects of the post-war amendments on the United States, most famously perhaps Bruce Ackerman's discussion of the Rump Constitution. So taken together, these post-war amendments are facially emblematic of precisely the shift from illiberalism to liberalism that Title characterizes as the first prong of transitional justice. Importantly, the reunification that followed the Civil War was designed specifically to distance the reunified nation from the slavery and sectionalism that preceded it. and President Lincoln's rhetoric during the war and during his acceptance of Southern surrender did not just accept the South back into the Union. Rather, it performed one of the crucial tenets of transitional justice. It distanced the newly reunified nation from the sectionally riven, enslaving one that preceded it. At the same time, Reconstruction seems to embody Titel's second prong, that the new regime tackle a redesign of the state's basic political, social, and economic institutions. Many historians have contended that had Reconstruction been fully implemented, it would have done much to fulfill the promise of black citizenship. And Titel's final prong is atonement. A desire to atone for wrongs done to black Americans was manifest in several post-war policies and programs, which can be divided into military, administrative, and political programs, and perhaps most famously was General Sherman's ordering of the redistribution of land, limited parts of land, to black Americans. Thus, in the rhetoric, policies, and politics of the Civil War and its aftermath, we can see the seeds of transitional justice. Yet one of the tragedies of my nation is the replacement of slavery with Jim Crow and the continued racial brutalities and disenfranchisements state-mandated and state-authorized. Instead of distancing itself from the illiberalism and inequality of slavery, the U.S. instead abandoned Reconstruction and embraced the illiberalism and brutality of what the South called, paradoxically, redemption, and what ultimately evolved into 70 years of Jim Crow racial apartheid. Of course, this culminated in the U.S. Supreme Court's infamous separate but equal proclamation from Plessy versus Ferguson. But similarly, the U.S. abandoned the institutional redesign contemplated by Southern Reconstruction, instead re-enfranchising treasonous white Southerners and authorizing, as I said, the redemption of the South. Finally, the long-awaited atonement to black Americans never came. Thus, despite a bloody civil war, 3 constitutional amendments, multiple Supreme Court cases, and endless statutes, the United States did not transition successfully from an illiberal, racially supremacist state to a liberal, racially egalitarian one. Instead, as legal scholar Reva Siegel has pointed out, the specific symptom of racial illiberalism, slavery, transformed into Jim Crow, peonage, and a set of repressive forces that were either state-mandated, Jim Crow and disenfranchisement, or state-authorized, such as lynching and interracial rape. Arguably, the great tragedy of the U.S. is not slavery. Rather, the great tragedy of the U.S. is that we did not fully transition from an illiberal, racially repressive society into a liberal one with equal, full black citizenship. Hence, my argument is that the U.S. is best understood as unfinished transitional justice, and this then offers the best juridical support for black reparations. Thank you.